What's up, everybody? So it happened. Something we have been expecting for a while has finally come down the pike here. The state has filed their notice of intent to seek the death penalty against Bryan Kohberger. Now, what this does, it creates all sort of procedural differences and things that are going to take more time and more money as part of this prosecution and defense. The jury selection process takes an extraordinary amount of time. Certain cases, they go one by one with each juror, trying to determine their thoughts and feelings on the death penalty. We know that now it is not one trial, but two. The guilt phase. Did he commit these crimes? And if he's convicted of that, they move into the penalty phase, where the jury has to weigh aggravating factors and mitigating factors to determine whether his sentence should be death or life. And because of all this, and even potentially certain things he may be entitled to now in discovery, will this cause delays? We've gotten a little insight into how this works with the Lori Vallow and Chad Daybell case. And I think we may see some of the same objections made, and maybe Bryan Kohberger's team eventually will try to get the judge to dismiss the death penalty charge or seeking of that punishment, as the judge did in Lori Vallow's case, because of some of the discovery violations or delays from the state, and the fact that Lori Vallow was in fact still demanding a speedy trial, as Bryan Kohberger is. And Bryan Kohberger's team is also accusing the state of discovery violations, blocking certain discovery. Will we see some similar arguments? Will there be any mental capacity or mental health or abuse like we've seen in the Nicholas Cruz trial if we get to a penalty phase in this case? This changes everything. It has been leveled up to the most serious penalty and crime charged in the United States of America. So let's take a look at this notice together. This is the notice pursuant to Idaho Code 184004A. We will read that after this notice. Comes now, the state of Idaho, by and through the Latah County prosecuting attorney, and hereby gives notice to the court, the defendant, and his counsel, pursuant to Idaho Code 184004A, that as of this point in time, and based on the information known to the state to date, the following statutory aggravating circumstances pursuant to Idaho Code 1925159 appear to exist in the case as to the crimes of murder in the first degree as charged in counts 2, 3, 4, and 5 of the indictment herein. So these are statutory aggravating factors that you must have and prove to a jury to get the death penalty. And the jury must unanimously decide for death. First, at the time the murder was committed, the defendant also committed another murder. Okay, we know that there was 4 accused here, so if they convict of that, that seems pretty easy. And or, number 2, the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. Seems like that would be here as well if he did it and they convict him of it. And or, number 3, by the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. Again, seems obvious. And or, the murder was committed in the perpetration of or attempt to perpetrate arson, rape, robbery, burglary, kidnapping, or mayhem, and the defendant killed, intended a killing, or acted with reckless indifference to human life, which is probably true and has the burglary element. And or, number 5, the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. If you do this, you're probably more likely to do it in the future if it's a crime this heinous. And there's the and or, so they don't necessarily have to prove all of them here, it looks like. The state gives this notice based on the fact that it has not identified or been provided with any mitigating circumstances sufficient to prohibit the triers of fact from considering all penalties authorized by the Idaho legislature, including the possibility of a capital sentence. Consequently, considering all evidence currently known to the state is compelled to file this notice of intent to seek death penalty. The state will continue to review additional information as it is received and reserves its statutory right to amend or withdraw this notice. The state can pull it anytime. They're not forced to continue to seek the death penalty in this case. As of right now, they are planning on seeking it, and they've notified the defendant that they are going to seek the death penalty. They've also said the defendant has not produced any mitigating factors, which would be potentially abuse or mental health issues or an alibi, right? They can prove he wasn't there. then obviously they wouldn't go for the death penalty. Or if it was an accident, or he showed up on scene and somebody else did it and he was forced to carry out the rest of it, whatever it may be, they have been shown no mitigating factors in this case. So right now, we have, less than 4 months before this trial has to happen. And this is filed within the 60 days. So will this delay the case? Will we see arguments that we saw in the Lori Vallow, Chad Daybell case? There were also certain arguments, if you remember, that the lethal injection medication was not readily available. And that we've heard rumblings of the firing squad being back in Idaho. How will the judge make those decisions? We've also heard discovery violation allegations and delays from the state. And they want to pause, the defense wants to pause the proceedings or stay the proceedings because of the grand jury indictment and the issues with getting those documents. Now that everybody says death is different, so because it has leveled up to the most serious penalty and crimes charge in America, the judge will have that in the back of his mind with every decision he makes on a stay, on discovery, on the grand jury proceedings. We do not want to violate any of the defendant's rights, especially when his life is literally on the line at this point. So I do think this is going to affect how the rest of the case is handled. I do think this is going to have an effect on the discovery disputes. I do think this is going to have an effect on the grand jury proceedings and the stay. And we will see how the judge deals with it. Judge Boyce, surprisingly to some, threw out the death penalty in the Lori Vallow case. And he mentioned the fact that, she may never get the death penalty because of the issues with the medication that they used in the execution. They also talked about how the state potentially had some discovery violations, how there was a long stay because of the capacity issues for Lori Vallow, and how all of that affected his decision to get rid of it. And again, that's literally the same state we are dealing with here. So in the comments, let me know what you think about this. Are you surprised? Is this what you were expecting? How do you think it's going to affect the case? Do you think we're still going to be able to get to trial within that 6-month speedy trial period? I have been of the mindset from the jump that that's not happening. And this makes me more confident in that projection. Not that it's a good thing or bad thing or whatever. That's just not how I see this case going. I think it would be very, very difficult to get there at this point. But I want to know what questions you have about this. So many videos today, so many things going on today, but I wanted to get this up tonight before it was old news because so many of you had questions about it during other lives. So let me know what you think about it. Sorry we didn't do it live. I'll still be able to get to your questions because I have a sneaking suspicion that there's going to be more Kohberger stuff happening. So thanks for joining me tonight. Hit that like button and share it with your friends if they're interested in it. But that's all we've got. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.